Hello, my name is Michael Brustein. I'm with the Washington, D.C. law firm of Brustein and Manasevit. We specialize in federal education and workforce law here in Washington, D.C. And I want to thank everyone for joining me today in this session on how to navigate funding under the Carl Perkins CTE Act, the Workforce Innovation Opportunities Act, and the Adult Education Family Literacy Act. We've got a lot to cover in a short period of time. Just a little bit of background about myself. I have been around the block a few times with regard to workforce development and career tech education. I actually began working on these federal programs back in the early 1970s under what was then called the Vocational Education Amendments of 1968. And I was the federal attorney in the U.S. Office of Education for adult literacy, for career technical education. I worked closely with the Department of Labor. I also had the opportunity to work in 1984 with the great Carl D. Perkins, congressman from Kentucky, who was the chairman of the House Education Labor Committee, in crafting the first Carl Perkins Education Act. And I've worked with legislative staff really in the reiterations Perkins 1, 2, 3, 4, and now we're operating under Perkins 5. I've been in a position where I've been able to author a number of books under the Workforce Innovation Act and the Adult Education Act and CTE, and I was delighted when ICEV asked me to assist in this process today. In the short period of time that I have with you, what I want to talk to you is understanding the three funding streams under these sources. Why? Because there's often a lot of confusion at the school level, at the local level, at the post-secondary level in terms of taking funding from different federal grants and really using them to serve the same purposes. And I want to talk to you today about the do's and don'ts of that particular process. So beginning with the Perkins Career Technical Education Act, here, this program is funded at about $1.3 billion. The monies go to the states from the U.S. Education Department. They go to what's called the state eligible agency, and then the states are required to follow a congressionally prescribed formula in allocating the funds from the state to both post-secondary recipients, PS, and local education agencies. That is opposed and different from the Workforce Innovation Opportunities Act, where the dollars go directly from the Secretary of Labor to the governor of the state. And then the governor also must follow a formula driven in large measure by unemployment factors throughout the state to what's called local workforce areas under the governance of local workforce boards. And of course, that is different than the way funds are distributed from the federal government under the Adult Education Family Literacy Act, which is technically Title II of the Workforce Innovation Opportunities Act. Here, the dollars go from the Secretary of Education to, again, the state eligible agency. That is the entity in the state designated by state law to administer this program. And the state does not allocate the adult ed funds by a formula. The state essentially runs a competition, and the competition must provide multi-year funding to literacy providers that score well against the factors that the state wants to use to run this competitive bid process. So each one, Perkins, Adult Ed, WIOLA Title I, the funds are allocated in a different fashion, and that's really important to understanding how this process might work. All three programs, however, are state administered using what's called the sole state agency concept. And the sole state agency concept really has been around for over 100 years. It really started when the federal government made its first investment in vocational education back in 1917 with what was then called the Smith-Hughes Act. And the thinking was that there would never be sufficient manpower at the federal level to administer these workforce and education programs. So an agreement would be reached with states to have the states implement these laws, administer these laws, and also serve as a fiduciary, that is the trustee, to make sure that the federal funds were being used for exactly the purposes that Congress wanted. So they came up with this term, state administered programs. Perkins, WIOLA, and the Adult Education Family Literacy Act are all state administered. The dollars go from the federal agency to the state agency. The state allocates those funds either by formula or by competition. But at the end of the day, if funds are misexpended at the local level or at the college level, then it is the responsibility of the state to pay those monies back. So when there are audits, when there's monitoring taking place and violations are identified, of course, our law firm has been involved. We've worked with all 50 states and as well as the territories on audit resolution. The federal government does not seek recovery from who violated the law at the local level or at the college level. They simply said to the state, we entrusted you with these funds. It was your responsibility to make sure that the federal funds were spent in accordance with the federal statutes and the federal regulations. The fact that that did not happen, we're asking you as a state to return those funds to the federal treasury. That is the nature of a state administered program. So with that being the case, it requires both the state as well as the local providers under these three programs to understand three very fundamental processes. Eligibility. Who are the eligible participants for each federal program? Obviously, if ineligible participants receive the benefit of these federal grants, those dollars need to be returned. 2, allowability. Is the item, such as the cost, the goods and services that are being purchased with these federal grant funds at the school level, at the local education agency level, or at the college level, are those funds being spent on allowable goods and services? Each of the three statutes has provisions on allowable uses of funds. And then we also have to look at federal regulations to supplement that list as well. And then third, and perhaps most important, is a separate process called allocability. And allocability means proportionate benefit. So for example, if a school were to use Perkins funds to purchase a computer lab or a whiteboard, but only 50% of the use of that computer lab is benefiting CTE students, then under the principles of allocability, only 50% of the cost for that computer lab could be charged to the Perkins grant. So questions come up all the time under eligibility, allowability, and allocability. It's the responsibility of the federal and state monitors as well as the auditors to ensure that when the dollars are allocated at the local level to the college or to the district, that the requirements on eligibility, allowability, and allocability are being followed. So who's eligible under the Perkins funds? And the statute's quite clear that Perkins dollars must serve participants and concentrators in CTE programs that are consistent with the local application that's been approved by the state. In other words, the authorization to spend dollars on paying for salaries, for paying for equipment, supplies, professional development, curriculum development, travel, must be set out in this local budget as part of the local application. And also under Perkins 5, for the first time in nearly the 60-year history of this legislation, it must be consistent with what's called the Comprehensive Local Needs Assessment, or CLNA. That is a new term that was introduced into Perkins 5, fully operational as of July 1, 2020. And it provides that each college participating, each local school district participating had to undertake an assessment. And that assessment was required to identify the difference in performance between the 9 specifically identified special populations under the Perkins Act, their performance in accord with the various performance indicators such as standardized tests, reading, math, science, high school graduation rates, and so forth, compare that performance to the non-special pop CTE students. And the purpose of the needs assessment in identifying the disparity or the gap between your special pops and the non-special pops was to require both post-secondary institutions and local school districts to spend the Perkins grant dollars on eliminating that disparity or reducing that gap over time. And that's a brand new requirement under Perkins 5, and we're now nearly a full year into that process. But that's the key for eligibility under Perkins. Under Title I of the Workforce Innovation Opportunities Act, there are 3 funding streams that total in excess of some $4 billion a year. And those funds must serve participants that are registered typically through what's called the One-Stop Center or the American Job Center. So essentially, the local workforce investment boards designated by the governor are required to establish these one-stop centers where participants under WIOLA will go to find out where can they receive job training, where can they receive a literacy training, for example. And they are registered through this process. And you want to make sure that your one-stop centers, as well as your providers of one-stop, your providers of services to individuals, participants under Title I of WIOLA, are documented through your providers, your training providers, your literacy providers, and so forth. And then with the Adult Education and Family Literacy Act, Title II of the Workforce Innovation Opportunities Act, the eligible participants here are individuals who must be at least 16 years of age, do not have a high school diploma, and are in need of literacy training. So it's a value added to workforce development that an individual who's seeking to develop skills to get a particular job at the one stop may be determined while they're interviewed at the one-stop center to be in need of literacy training, and that a service is aligned with that particular individual, and the adult ed dollars are used for that purposes. And adult ed is funded really in the neighborhood of about $700 million per year. So again, eligibility under Perkins, eligibility under WIOLA, eligibility under adult ed, each carried their own requirements. Is it possible to have an alignment where individuals are benefiting from more than one? And I think that that's clear. The answer is yes. For example, youth training under the Workforce Development Act may also be, that participant may also be a beneficiary of Perkins CTE programs, but you want to make sure that you are satisfying all of the eligibility requirements. So after you get through that first gate of eligibility, you want to make sure that the federal dollars that you're spending are being used for allowable purposes. How do you do that? How do you make sure that your federal grant dollars that you're using in the classroom are allowable? Well, the answer to that is first, you look to the statute. And as I mentioned, the statutes have information on this particular provision. So for example, under Perkins, section 135 sets out the mandatory uses of these funds. You would find that under the Adult Education and Family Literacy Act, as well as the Workforce Innovation Act as well. Mandatory uses of funds, often suggested permissive uses of funds as well. But your inquiry does not stop there. It must also include a fundamental understanding of a document called the Uniform Grant Guidance, short UGG. The Uniform Grant Guidance is a set of executive regulations put out by the Federal Office Management and Budget, really part of the White House. And that provides guidance to the 28 federal agencies that issue nearly $1 trillion a year in federal grants, which would include the Department of Labor for the WIOLA grants, as well as the U.S. Education Department for the adult literacy grants and the Perkins CTE grants. Subpart E of the Uniform Grant Guidance specifically is devoted to allowable costs. And it sets out 55 elements in alphabetical order, telling the reader either this particular item, such as compensation, is allowable, or the particular cost, such as alcoholic beverages, is not allowable, or that certain items, such as purchase of capital expenditures and equipment, are allowable, but only as long as you have the approval of the pass-through agency. So it's either, it's going to say it's allowable, it's going to say it's unallowable, or it's going to say it's allowable with certain additional conditions. So this regulation, summarizes that here. There are rules on 55 separate activities. So if you are participating in this session today and you have a responsibility for developing a budget, reviewing a budget, or approving that budget, you want to make sure that you understand subpart E of the Uniform Grant Guidance. Is the particular item, such as student support costs, travel, meals, conferences, and in the short period of time we have today, I'm not going to be able to go through those, but the answers are provided in the Uniform Grant Guidance. Again, is it allowable? Is it flat out unallowable? Or are there additional limitations, such as specific approval of the grantor agency or the approval of the pass-through agency? And by the pass-through agency, I mean the state eligible agency, for example, under Perkins Act, or the governor's office under WIOLA Title I. Okay, and then the next part of this process in terms of navigating the cost under these three programs is you need to ask yourself three questions. First question, is the item that I want to purchase with the federal dollars necessary in order for me to carry out this activity? Do I really need to purchase a computer lab if I just purchased a computer lab last year? Now think about that. Can you use the funds on a computer lab? Absolutely. But if you just purchased one last year, and of course it's a formula program where you're going to get the funds this year, would you want to go ahead and purchase another lab, or would it duplicate something that you already have? You do not want to duplicate services. Or you might have a superintendent that says, well, we're getting these federal grants under the Perkins Act. Please put into the budget that I would like to purchase a Cadillac Escalade because our school district covers a lot of square miles. Well, you've got to ask yourself, is that Cadillac really necessary for the operation of the CTE program? And I think the answer is not. You've got to ask and answer these questions because clearly the auditor is going to look at everything that was purchased over that 12-month period, and they're going to ask the question. So, I mean, just a couple of minutes ago, I was on a call with a client, and they brought up school districts using funds to purchase Ming vases from China. And obviously, you'd be hard pressed to say that it is necessary for a school district to go ahead and buy art, such as the Ming vase, to run their CTE program. Auditors would never buy it, and those dollars would simply need to be returned. The next gate is the cost reasonable? So you need to buy a computer for your particular program. You could probably get a $3,000 Mac or a $400 Dell. And then you've got to ask yourself, would the $400 laptop meet my particular needs? Or would I need a more elaborate? Just because you can buy a more expensive one doesn't mean that you should. And the legal standard is what would the prudent person do in the comparable circumstances? Would the prudent person go ahead and get the top of the line computer, or would the reasonable person, prudent person, go out and get simply the computer that meets their needs? And it would clearly be the latter. Or if you're attending a workshop, say our workshop in December in Las Vegas, and you can fly coach or you can fly first class, you've got to ask yourself, what would the prudent person do? And again, that would be to fly coach. And then again, the item is necessary, you've determined the cost is reasonable, then make sure you do proportionate benefit. If you're paying a guidance counselor, if you're paying an instructor, for example, and only half the students are CTE, then only half the cost of that counselor, half the cost of the salary of that particular instructor, it would be allocable to the Perkins grant. So again, you need to keep those in mind as you move forward. So here, the example, what does allocable mean? A proportionate benefit. A computer lab, it's used only 50% for CTE students and 50% for adult literacy. It's a requirement of the district to bifurcate the cost, pay for each 50% with each funding source. Now, there are two terms that are often bandied about when you look at multiple funding streams, such as Perkins, WIOLA, and adult literacy. One term is braiding, the other term is blending, and they're used more and more frequently. Braiding means that at the local level, you are making an effort to coordinate, to work in union with the folks that are your literacy providers, your CTE providers, and your workforce development providers. You may want to target certain special populations with these funding streams. That's called braiding, to try to coordinate to make sure you're satisfying the eligibility, the allowability, and allocability on all three, but you are coordinating the funding in doing that. That term is different than the blending. The blending of funds is where you actually consolidate or commingle the funds into one silo. So you would take Perkins dollars, adult literacy dollars, and WIOLA Title I dollars, and you would deposit it into one local bank account. And then when the dollars are all deposited into that one account, you don't have green dollars and red dollars, you have just one set of dollars, and then you go out and you start making expenditures. Let me say this, and you need to be cautious with regard to blending, but you need, more importantly, statutory authority to do so. And by that, what I mean is that The Perkins Act, Adult Literacy Act, and WIOLA Title I allow blending of funds to pay for infrastructure costs. These are non-personnel costs to run these one-stop centers. In that instance, it's perfectly lawful to blend the funds together. But that is the only scenario where those three funding sources can be blended together. Another one that some of you may be familiar with is under Title I of the Elementary Secondary Education Act in terms of school-wide programs. If more than 40% of the student population is in poverty, then the statute permits the blending or school-wide consolidation of those funds. But the important point to stress here is absent statutory authority to blend or consolidate funds, it's best to coordinate the funds and keep them in separate funding silos. Now, you may hear folks say, no, the future is to break down the silos, put it all in one. But again, if you want to be sure to avoid audit exposure going forward, never consolidate funds unless there's statutory authorization to go ahead and do that. And of course, we've got to keep in mind performance. So each of the three statutes, Perkins, Adult Literacy, and WIOLA, have both indicators of performance and measures of performance that you are required to come within 90% of those particular measures. And if you do not come within 90% of what you've negotiated with the state on each of these performance indicators, then the state is authorized to impose sanctions. Now, under adult literacy and WIOLA Title I, the sanctions could be severe enough to require the governor to disassemble the local workforce investment board and recreate that local board. It also could result in less funding available to the governor under Title I of WIOLA if for more than 2 years in a row, under any one of these indicators, the state fails to meet that 90% threshold. With regard to Perkins, again, if there is a failure to meet that 90% threshold in any of the performance indicators, then that college or the district would be required by the state to enter into a corrective action or local improvement plan to be monitored by the state. So again, it's the college's responsibility to reduce the performance gap between your special pops and your non-special pops. If you're not successful, you are required to come up with new strategies in which to do that. But the state has the authority to actually move the dollars away from the college or the school district to provide it to another organization to provide that service. That rarely ever happens, but it is there, it is on the books, and I certainly wanted to share that with you. And then in closing here, there are many of you out there that I've had the pleasure and the opportunity to work with in the past. We run forums ourselves on federal grants management. We, on July 1, will be announcing our own forum. We've been doing this for 30 years now in Las Vegas. It will be in person. So if you are interested, please just check out our website, www.brewman.com on July 1 to get the information. And we will be going into depth over a 3-day period on federal education and workforce development grants management. And with that said, I just want to thank you all for joining this session, and you automatically will be awarded points for attending the session. At the end of the conference, you'll be receiving a digital certificate noting how many sessions you attended. Good luck with the rest of the session. And again, thank you for the privilege of your time.